Hello again. Welcome to the second of these series of podcasts about children's views and the role of social science in family law. In this podcast, we'll be examining the effect of the Family Law Amendment, Shared Parental Responsibility Act 2006, and so described shared care arrangements, including the social science research about when equal time or substantially shared time arrangements are in a child's best interests. The Family Law Amendment Shared Parental Responsibility Act 2006 amended Part 7 of the Family Law Act significantly. A number of the sections that you have already considered were inserted in 2006. These include Section 61 DA, the presumption of equal shared parental responsibility, and Section 65D A, that is, equal time and substantial and significant time arrangements. Notwithstanding that more than 10 years has passed, these amendments remain the subject of some controversy. In those circumstances, it is appropriate to examine and consider some of the published research. The policy objectives of those amendments were said to be, amongst other things, to encourage the greater involvement of both parents in the lives of a child and to encourage parents to reach agreement without going to court. For example, Section 60 I, that's attendance at family dispute resolution, was part of the 2006 amendments. Before 2006, there was no legislative requirement to attend family dispute resolution before commencing parenting proceedings. There appeared, at the time the amendments came into effect, to be a degree of misunderstanding about the effect of the legislation. In particular, there was a belief amongst some that the presumption of equal time, or a right to equal time, arose from the legislation. The Honourable Mr. Richard Chisholm, a retired family court judge, prepared a report entitled The Family Court's Family Violence Review. In that report, he specifically referred to community misunderstandings about the effect of the legislation, including a lack of understanding by some lawyers, as a difficulty. The decision of C and B, which is referred to on your slide, for an example where a family report writer who prepared a report pursuant to Section 62 G, which we'll address shortly, made certain recommendations based on incorrect assumptions upon the effect of the amendments. Moreover, some judicial officers felt that they were obliged to make orders for equal time. One example of some of the issues that arose following the amendments is the case of Skelton and Donaldson from 2007. Skelton and Donaldson was an appeal against an interim decision by the then Federal Magistrate, now Judge, Jarrett. The child was 18 months of age. The facts were that the father had been in jail for armed robbery and had previously been a heroin addict. The relationship with the mother was subsequent to those events. While the parents were in a relationship, the mother had left the child in the care of the father at times. The mother sought orders that the child live primarily with her. The mother's evidence was that she had been subjected to family violence during the relationship. There was, on the evidence, a very high degree of conflict between the parents. On an interim basis, Judge Jarrett ordered that the child live with each of the parents on a 3-day rotating basis, that is, 3 days with one parent, 3 days with the other parent. On appeal, Justice Warnick of the Family Court of Australia dismissed the appeal. His Honour remarked that, in his view, it could be fairly said that there was a legislative intent in favour of substantial involvement of both parents in their children's lives, both as to parental responsibility and as to time spent with the children, subject to the need to protect children from harm, from abuse and family violence, and provided it is in their best interests and reasonably practicable. You can consider and make a decision for yourself whether, in light of the subsequent amendments to the Act, that is, those passed in 2011 and coming into effect in 2012, and the research and evaluation of the amendments undertaken since, whether the orders made in this case were A, consistent with the actual legislation as it is drafted. For example, look at Sections 4AB as it is now, and also Section 61 DA3 about interim proceedings, and B, consistent with the social science research already considered in this module about what arrangements might be appropriate post-separation for a child. Extracted at page 770 of the casebook is a 2010 research paper from the University of New South Wales examining the suitability of shared care arrangements. This is a good introductory reading to examine some of the issues. Some of the research appears to show that in cases an equal time or substantially shared parenting arrangement can be successful. They can work for children to maintain a close relationship with both parents. Some children perceive such arrangements to be fair to both of their parents. However, the key seems to be that parents need to be able to successfully communicate with each other. For example, parents need to be able to solve between them the practical everyday problems such as schedules for extracurricular activities, homework, or items being moved from house to house, for example school materials, or clothes, or toys, or other items. The slide that's in front of you now provides a good list of the published research about shared parenting arrangements. Working your way through all of that is probably beyond the scope of this course and certainly beyond the scope of these podcasts. But if you're interested, all of those materials are good additional or background reading about shared care. The Australian Institute of Family Studies published a paper in 2004, that is before the shared parenting amendments were inserted into the Act, that came to some conclusions about the circumstances in which shared care or equal time arrangements are more likely to succeed. Those factors included the geographical proximity of the parents, cooperative arrangements of parents, mutual commitment, and a degree of financial independence. There is some even earlier research from 1999 that suggests that the issues are different again when it comes to teenage children. This research, which is in front of you, suggests that as children become adolescents, they may wish for their arrangements to become more flexible. This was based on evidence that identification with peer groups was more important for some children, and movement between households was disruptive to those connections. In those circumstances, some children might revert to or express a view about living with one parent primarily and spending time with the other parent. Professor Belinda Fehlberg, in her 2011 article, noted that shared care can be defined in different ways. You should take this into account when reading the material. Equal time and shared care may not be the same concept. Some of the research defines shared care as spending at least 30% of nights with each parent. Without doing the mathematics precisely, a more traditional sort of arrangement in which children live with one parent and spend time with another parent on alternate weekends and for half of school holidays probably amounts on the maths to a bit less than 30% of any given year. For an arrangement in which children spend more than 30% with a parent of each year, it's probably got to include nights, say for example, from after school Friday to before school Monday, and one other night during the other week of any fortnight. Once you do that, then the mathematics and doing my best about the maths probably work out to the children spending about 70% of the year with one parent and about 30% of the year with another parent. Moving back to Professor Fehlberg's research, she found that there was a tendency for children to drift back to an arrangement where one parent was the primary carer. On her research, it was mostly mothers. The research also suggested that shared care was of significant risk to children if children were under 4 years of age, or there was high conflict between the parents, or there was domestic violence. There is some research that suggests that particular care needs to be taken in considering equal time or near equal time arrangements for children under school age, irrespective of whether or not the parents were cooperating or the level of communication or interaction between them. Let's turn though to the concept of attachment theory. The concept of attachment theory is one that, in summary, the children develop a primary attachment to one parent in their first year, and having developed that attachment, will be distressed if removed from that person for any extended period. Jennifer McIntosh, a well-known Australian researcher, in her research agrees that development of secure attachment is important for a child's long-term emotional health, although there is some disagreement about how this translates into parenting arrangements post-separation. McIntosh suggests that frequent transitions for infants can bring about potential developmental difficulties, particularly when there is ongoing acrimony between the parents. She says that frequent transitions necessarily interrupt the infant's experience of care with each parent, especially the relationship with the primary carer if there has been one. The result, she says based on the evidence, is ongoing developmental difficulties for children. One other example of the research, and in part expressing a different view about very young children, is the 2011 article that's on the slide in front of you. This research suggests that there should be no overnight time at all between a child and the parent that the child is not living with until the child reaches 2 years of age, with a gradual build-up thereafter. You can see from these different research perspectives that there is no singular settled social science view about what the best arrangements are for children and or whether or not a shared care or equal time arrangement is or is not appropriate or is in a child's best interests. It is not appropriate for us in an undergraduate law course to evaluate the quality of the research or to advocate a particular view. It is important though for you, in background terms, to understand that the research exists and there are many views within the social science discipline about what arrangements are in a child's best interests. Next, and the final podcast for this subject, this module, will be that of how the views of children are placed into evidence before a court, and other procedural matters such as family reports and the appointment of independent children's lawyers. However, that's it for this podcast. Thanks for listening. Bye for now.